Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here. This morning, you was asked to come to court for what we call an arraignment. Arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is classified as a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Felony cases are your most serious type criminal offenses, whereas your misdemeanors are normally referred to as petty offenses, but it does not mean that they are not serious. They are serious. The difference between your felony cases and your misdemeanor cases is as follows. With the felony cases, your punishment can require you to be sentenced to the state penitentiary. With the misdemeanor cases, you cannot be sentenced to the state penitentiary. However, your sentence can include punishment in the Jefferson County Jail. Felonies are divided into various categories. You may have capital murder, first-degree felony, second-degree felony, third-degree felony, or state jail felony. If you have a capital murder, the range of punishment is life or death if you're convicted. If you're convicted for a first-degree felony, the range of punishment is anywhere from 5 to 99 years to life in the state penitentiary, fine up to $10,000. If you are convicted of a second-degree felony, range of punishment 2 to 20 years, fine up to $10,000. Convicted of a third-degree felony, range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. And the lowest felony that you have is what we call a state jail felony. The range of punishment for a state jail felony is a minimum of 6 months to 2 years in the state jail. If you are convicted of a misdemeanor offense, we have 3 categories of misdemeanors. We have a Class A, a Class B, and a Class C misdemeanor. Your Class C misdemeanors are fine only. You only could be given a fine for those offenses. You cannot be given any jail time. Those cases are normally in the JP court or the city court. For example, a traffic ticket is classified as a Class C misdemeanor. So you only can get a fine. You can't be sent to the jail. Your punishment cannot be or cannot entail you being sent to county jail. Now, for a Class A misdemeanor, which is our highest misdemeanor, your range of punishment can be anywhere from a minimum 0 days to a maximum of a year, or anywhere in between. In the county jail, you could be given a fine from $0 all the way on up to $4,000 or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days, which is 6 months in the county jail, or anywhere in between, a fine from $0 to $2,000 or anywhere in between, or you could be given both such fine and confinement. Now, you may be eligible for probation, and if you are eligible for probation, there are 2 types of probation. One type of probation is called deferred adjudicated probation or unadjudicated probation. The other type of probation is regular probation, and that's adjudicated probation. The difference between the 2 is as follows. With the regular probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, which means that the court can set aside the conviction. And in order for that to happen, a couple of things has to happen. First, you have to successfully complete the probation. You cannot have any more time left on the probation. The probation has to expire. And the court has to successfully discharge you from the probation. If those things happen, then the court can allow you to come back in the court to withdraw your plea of guilty or no contest. And if that happens, then the court can set aside your conviction. But and the way it operates, the court can allow you to come back into court to withdraw your plea, and any complaint, affidavit, or information that has been filed against you will be dismissed. Then the court can set aside that conviction. And however, if you get a subsequent conviction later on, then this case can be revived, resurrected, or brought back up. It could be used against you. And if you try to get a license with CPS, or if you have a license with CPS, they can suspend or revoke that license. Or if you try to get a license, they could deny giving you a license with CPS. Now, the other type of probation is called unadjudicated probation or deferred probation. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record. And the way it basically works is if you don't have a conviction on your record because you successfully completed deferred adjudicated probation, then you may qualify for what is called a non-disclosure. And what a non-disclosure is, we cannot disclose to the public the fact that you were on deferred adjudication. Now, however, if you violate your terms and conditions of your probation, the state can file a motion to revoke your unadjudicated probation. If the state file a motion to revoke your unadjudicated probation, then you'll be entitled to a hearing for the court to determine whether or not you violated your probation. If the court finds that you have violated your probation may be revoked. And if your probation is revoked, obviously, you may get a conviction on your record. And if you get a conviction on your record, you cannot get a non-disclosure. Now, as a defendant in a criminal case, you have rights. One right that you have a right to have an attorney. And if you have enough money to hire an attorney, then your case will be reset to allow you, give you time to hire an attorney. If you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you, or you may represent yourself. In essence, you can waive your right to hire an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind and request counsel from the court. Mr. Bailiff, somebody's back. At the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my attorney, then the application that we give you, you'll have to put your initials on the first line to the left. If you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. Or if you've already been appointed a court-appointed attorney, you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Now, at the bottom of the document that we're going to hand out to you, once you finish initialing one of the 5 lines, you'll sign at the bottom where it says defendant, and you'll date it today's date, December 7th of 2021. For those of you who will be representing yourself, you'll sign another document, which will be the second page on the paperwork that will be handed out to you. And it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised the 7th day of December of 2021 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge, understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel. I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your choice, you'll sign at the bottom of that document where it says defendant, and you will date today's date, December 7th. Now, you also have a right to have a jury trial. And what a jury trial is, that area over there where those 12 chairs are, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case as a jury. They will decide whether or not you're guilty or innocent after listening to all of the evidence in your case. You have a right to waive your right to a jury trial, which means you have a right to give up your right to a jury trial. And by doing so, you would not be having a jury trial. And your case can come before the judge or the court in one of 2 ways. It can come before the judge by way of a trial, or it could come before the judge by way of a plea. And I'll explain that to you. If it comes before the judge by way of a trial, in essence, you'll have a trial without a jury. The judge will be the judge and jury. And after listening to all of the evidence, the judge will decide whether or not you are guilty or innocent. And then the judge can also assess punishment. Now, you also have a right, if you decided to enter a plea of either guilty or no contest, your case will also come before the judge by way of a plea. And it can come before the judge by way of a plea. What a plea is, it's an agreement that you and the state have made together. We call it a plea bargain agreement. If you and the state have reached an agreement to settle your case, we call that a plea bargain agreement. And if you want to enter a plea of guilty or innocent, guilty or no contest to the charges, your case will come before the judge by way of a plea bargain agreement. And a judge doesn't have to follow that plea bargain agreement. If the judge does not follow that plea bargain agreement, you'll be entitled to withdraw, which means you will be entitled to take back your plea if the judge doesn't follow the agreement that you and the state have reached. Now, if the judge does follow the agreement that you and the state reach, if you want to appeal your case, you have to get permission from the judge to appeal your case. And the other thing is, if you and the state are unable to reach a plea bargain agreement, but you still want to enter a plea of guilty and no contest, and you want your case to come before the judge, then the judge at that point will decide what your punishment will be if you cannot reach an agreement. That's called an unagreed plea. You also have a right to have witnesses to testify in your case. That area over there where that chair is turned, we call that the jury, we call that the witness stand. And what witnesses do, they'll testify. They can testify for you, against you. You can ask them questions. We call that either direct examination or cross-examination. Or if you're represented by an attorney, your attorney will be asking the questions on your behalf. Now, you also have a right to waive your right to have witnesses or give up your right to have witnesses to testify in your case. And by doing so, you will not be calling any witnesses in your case. However, the state will be calling witnesses in the case. You have a right against self-incrimination. What self-incrimination is, you may have heard the term taking the fifth. That simply means you have a Fifth Amendment right against self-incrimination, which means you have a right not to testify in your own case. And if you exercise your Fifth Amendment right, then you will not be testifying in your case. However, you also have a right to waive or give up your right against self-incrimination. In essence, you have a right to testify in your case if you waive your right not to testify. Now, you also have a right of discovery. We call what discovery is, you have a right to see the evidence. That's what discovery is, to see the evidence that the state has against you. You have a right to see the videos, the witness statements, documents, or whatever evidence that they have. You have a right to have access to that evidence. Or if you're represented by an attorney, your attorney will have access to that evidence on your behalf. Now, you also have a right to waive or give up your right to discovery, which means you have a right not to see that evidence. You do not want to see the evidence that the state has. You have a right to waive or give up your right to see that evidence as well. Now, Jefferson County, well, first of all, let me explain when I mentioned that you could enter a plea of guilty, no contest. Actually, you could enter one of three types of pleas. You could enter a plea of not guilty. And if you enter a plea of not guilty, you're telling the court that you didn't commit the offense that you've been charged with. Or you could enter a plea of guilty. And if you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges that you have been charged with. Those are the three types of pleas that you can enter in your case. Now, everyone who's here for arraignment, you've been arrested on your case and you're out on bond, either surety bond, cash bond, or PR bond. And that just simply means that you spent some time in jail. You either spent one or more days in jail. If you and the state have reached a plea bargain, now let me explain this to you. Every day that you spent in jail, you can get credit toward your punishment. So for example, if you spent 5 days in jail and you and the state have reached a plea bargain agreement, and that plea bargain agreement is for you to serve 5 days in jail, you will not have to serve any more time in jail because the time that you spent in jail has already satisfied the punishment. You could be given what is called credit for time served. In essence, you won't have to spend any more time in jail because you've already served enough time in jail. Now, if they offer you 7 days in jail and you serve 5, that just simply means you have to serve 2 days in jail. Now, every day that you spent in jail, you get credit at $100 per day toward your fine and court costs. So for example, you spent 5 days in jail, that's $500. So if the state is offering you a fine and court cost of $500, you would not have to pay anything else. Why? Because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they offer fine and court costs of $700, then that simply means that you would have to pay $200. Now, if you are unable to pay the $200, then we could put you on what is called a payment plan. In essence, you could pay it off in installments until it's paid off. Now, if you're unable to pay it off even in installments, then we can convert your fine and court costs to community service. In essence, instead of paying off the $200, you'll be working it off in the community by doing community service. Now, every hour that you work in community service, $12.50 will go toward your fine and court costs. So if you work 8 hours of community service in a day, that's $100, okay? Now, also, Jefferson County, the district attorney's office, that is, has a program that is called pretrial diversion. Pretrial diversion is a program whereby the district attorney office will dismiss your case if you get into the program. And if you successfully complete the program, then the case can be wiped off, erased, or expunged from your record. Now, in order to qualify, it has to be your first case. You can't have a criminal history. You have to have an attorney to assist you get into the program. And it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. So if you qualify, get into the program, The case is dismissed, you complete the program, you can get it expunged. Expunged means erased, wiped off, or deleted from your criminal record. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court. It's for veterans only. And if you get into the program, it's part of the pretrial diversion program. Case is dismissed, you complete the program, you can get it expunged, deleted, or wiped off from your criminal record. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative. Community Safety Initiative stands for what we call it the CSI program. And the CSI program is a program that is designed to address what is called recidivism. Recidivism is when people commit crimes over and over. They do one crime and they commit another. And so to address that, to prevent it from happening again, we have the CSI program. And the CSI program is designed to make Jefferson County a safer place for all of us to work, go to school, raise our children, go to church. And the way the program works, it addresses the issue, as I said, of recidivism. And the reason why people commit crimes is because there's a cycle. The cycle normally starts off with individuals who do not have an education, can't get a job, they can't get a job. They usually turn to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. Once they commit a crime, they eventually get caught and do time. And once they do time, they eventually get out, and then they right back into that same cycle. So in order to break the cycle, have the Community Safety Initiative. And with the Community Safety Initiatives, we have partnerships with local agencies in our community. We have a partnership with Spindletop Center, which is our local mental health agency. And we have mental health officers as well as counselors who's in court. They're in court today, and they can provide private interviews. They can, Spindletop can do an assessment. They can develop treatment plans, either outpatient or inpatient treatment for anybody who have any mental health needs. You know, your mental health needs could be depression, bipolar, schizophrenia. It could be anxiety, post-traumatic stress, or just a whole host of mental health issues that they can help address. Now, if anyone has issues or problems with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And with that program, they can provide a private interview, screenings, and they can develop treatment plans, either outpatient or inpatient treatment for anyone who have issues with drugs or alcohol. This court also has a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you would like to get your GED, then CICE has a GED program as well, where they can assist you with getting your GED. Now, all of these programs that I've just mentioned are free. They do not cost you anything. Only thing you have to do is have a desire to be in the program. I tell people this all the time: when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in the community in which we live, Jefferson County. Now, in this court, we do not just give time. We take our time by addressing the problem instead of just simply arresting the problem. So we don't just arrest the problem, we address the problem. So whatever problems that you have, then we will address those problems. The other thing is, with our program, we're producing productive people. And we believe that producing productive people, for the most part, productive people do not commit crimes because they have too much to lose. And so if you're interested in one of those programs, just please let us know. And as I said earlier, those programs are free. They do not cost you anything. It does not cost Jefferson County anything as well. We have Deputy Hinton, who's here from Spindletop. He's one of our local mental health officers, and he's going to come before you and tell you give you some information about Spindletop and the programs that they have at Spindletop. So at this time, introduce to you Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. Judge said I'm speaking. I'm about the state of Texas. The reason I'm here is because the judge everyone comes before his court. And he has graciously allowed us in his courtroom to help everyone who comes here. What we have found is people who come in and out of the court system, who cycle in and out of arrest, the court system as far as the courtroom, have sometimes mental health or substance use disorders. We can help you with that. If you want help, this is a voluntary situation. It's a quality of life that is based upon whether you want to receive any assistance. Now, it's going to require you to let me know. We can speak privately. At the very least, I want you to have this card. It has a 1-800 number on there. Should you ever find yourself in an unsafe place, you got a 1-800 number. You can call. It's a crisis hotline. They can help you immediately. There's another number on there where we can work with y'all, going through Spindletop and advocating for y'all with the services that y'all best need. And we have a couple of qualified mental health professionals who are here with me today. They can speak to you in private, and we're not here to embarrass anyone, but we are here to provide services that y'all feel like that y'all would need, or maybe help y'all get out of the cycle again of arrest. If this is something you're interested in, when the judge goes into recess, I will be going out and visiting with each one of y'all, and I'll get you one of these here. If you want to speak privately, we'll be allowed to do that this time back in the jury room. Does anyone have any questions? Thank you very much. You're very kind. I'll be talking.
Okay, thank you, Deputy Hinton. Now, the program that we have with Spindletop, or the Community Safety Initiative Program, has been in place since March of 2017. Program that I started within the first 100 days of me taking office. Program have helped hundreds of people. So if you're interested, as I said earlier, all of these programs are free, does not cost you anything. And these are just part of our pre-trial program that we have started here. Now, we're going to take a few minutes to pass out some paperwork to you, the paperwork that I mentioned, where you'll have an opportunity to tell the court whether or not you would like to hire an attorney, whether or not you want to see if you qualify for a court-appointed attorney, or whether or not you would like to waive your right to an attorney and to represent yourself. And so just bear with us. It's going to take a few minutes to pass out, and then you'll go over the paperwork. If you need any assistance, we have some of the court staff here will be happy to assist you with the paperwork. So at this time,